minds meet now. So when I saw this order first being conceived, I went around talking to people. I was like, amici at the district court hearing. And I asked my wife, who's a brilliant legal scholar, does this happen? She's like, no. I asked everyone else. People were like, I've never seen it, or maybe once or twice. So how common is this?
So it's not that uncommon to file an amicus brief in the courts of appeals. That's pretty common. And sometimes an amicus brief in the district court, particularly on novel issues, which I would argue this is not novel. But to actually invite amici who don't represent sort of a government entity or a sovereign entity like a foreign government, to invite amici to actually participate in oral argument, I've never seen it in my career in the lower courts. And even in the U.S. Supreme Court, in 35 years between 1980 and 2015, out of the over 4,000 arguments the court held, they had amici present argument in 1,000 of those cases, but only 9 of those were people not representing a governmental entity or foreign sovereign. That is how exceedingly rare it is.
Right. That's what's so wild. It's like usually when this happens, it's like, Texas, you're not a party to this, but you've got an interest here, or the Department of Justice. Come on in, Department of Justice. This is just like, you're a guy with some takes. Like, you just have takes. You have takes on the constitutionality here, but you're not connected to the case at all. You just got some opinions about it.
That's right. And, each does express their interest, the interest of the amici they represent, and why they think that what they have to say would be helpful to the court. That's what they say in their motion to file the brief. And so, again, I'm not surprised the court allowed some of these briefs, but to give them 30 minutes each of argument time in what she is now scheduled for an full day of arguments on just one part of this issue, whether the appointment of the special counsel violates the Appointments Act, not even the other half of the issue that Mr. Trump argues, which that it also violates the Appropriations Clause of the U.S. Constitution. First of all, that's an extraordinary amount of argument time on this single issue. And to invite amici to present 30 minutes of argument. Most oral arguments in courts of appeals aren't even 30 minutes per side per party. So this is really extraordinary. I will say, though, the two amici who requested oral argument representing amici who support Donald Trump's motion, there was an amicus brief filed on behalf of those who are supporting Jack Smith's side of this. And those people said, if the other guys are going to get to argue, then we want to argue too. And Judge Aileen Cannon did grant that. So we will have someone arguing as well who's supporting Jack Smith.
Again, I'm straining to sort of communicate this to non-legal people, because I think legal people are like, every time Cannon does something, more or less, legal people are like, okay, this is a weird one. She's running her own little Supreme Court there on this on this constitutional issue. She's a district court judge. Look at 2018, another federal judge who is a Trump appointee upholds constitutionality of Mueller appointment. It is settled precedent. This has been challenged before. This is settled before the Supreme Court. Now, if the Supreme Court wants to overturn it, which Lord knows they can, but as the district court judge, she's got clear marching instructions here. She's not wrestling with something that hasn't come up before, and she's running her own little Supreme Court for an entire day with amici and everything for a full day of arguments.
It's extraordinary. I mean, she would probably say, well, the 11th Circuit hasn't directly ruled on this. And Mr. Trump and his amici argue that the Supreme Court case that Jack Smith relies on, U.S. v. Nixon, they make arguments that what the court said there was dicta and it doesn't apply here, et cetera, et cetera. So she, I guess, at least sees a little path where she's not bound by previous decisions. And again, if she were to rule in Mr. Trump's favor on this, these are things, and, what he's asking for is a dismissal, right, of the indictment. These are things that could be taken up to the 11th Circuit. I'll note as well that even if there is some problem with the appointment, and again, I don't think there is at all, Jack Smith is an inferior officer. It's clear under statutory authority and the Constitution that he can be appointed by the Attorney General of the United States. I think that's quite clear. But even if there was some other path, there's a doctrine that says when actions have been taken such as this, you don't go back and unravel that action because the appointment was unlawful. That's the a doctrine that's accepted in law. You move forward and you change things moving forward, but you don't go back and unwrap what's already been done. So there's so many reasons why this is wrong.
I mean, I would say, again, trying to sort of be fair here and not allow my own biases to color how I see this. In the main, this judge has taken a bunch of actions and not taken a bunch of actions that have led to a lot of delay. And I would say a sort of surprising degree of solicitousness towards defense's arguments, no matter how outlandish they seem.
I agree with you, Chris. I do think some of it is her inexperience, her lack of confidence, apparently in her, in her own ability to make judgments based on the written record. Many of the motions that we've seen here that she has had argument on, not to mention argument lasting an entire day. And this is not the first time she's had arguments go for an entire day. Many of these are motions that I think other more experienced judges would have ruled on just based on the papers. There is no requirement that she actually hear argument from the parties in court on every issue. Argument is supposed to just really be an opportunity for you to ask the questions that you don't feel as a judge were resolved in the papers. So that's even all the more reason why you have no need really to hear from non-parties, people who just have an interest and file a friend of the court brief. Because any questions you might have based on their briefs, guess what? You can ask those questions of the parties, the counsel who are in there. You can say, to Mr. Trump's lawyer, so-and-so filed an amicus brief arguing that. I have a question about that. Can you respond to that? And if they can't, they can say, we'll file a supplemental briefing. So, there are many ways for the court to get its questions answered, and this really is quite extraordinary.
All right, Mary McCord, thank you for sharing your expertise with us. I appreciate it.